So welcome to the concluding panel of what has been, I think, a very important, very successful conference. I missed the introduction as to what the purpose of the conference was, but as I understand it, it's been fulfilled. The topic today, appropriately enough, is the presidency in the post-9/11 world, and we have a really terrific group of people to help us think through it. I'll introduce them briefly, introduce myself, briefer still, and just say a couple remarks to get us going. I'm David Barron. I was the acting assistant attorney general for the Obama administration from inauguration day for the first 18 months. So the topic is one that I'm interested in. And it's one that raises a whole host of questions. We could talk about it at various levels, some of them quite detailed, the extent to which particular legal doctrines of the presidency have or have not changed. We could talk about it at a predictive level. How will the presidency change going forward? We could talk about it in a grander historical context. To what extent is the presidency now truly different than it has been at other times? We could talk about it at an ideological level. The 2 points I want to just start with is that it is not a surprise in history that a serious national security crisis will change the presidency. That's been true over time. It's also the case, though, that when we talk about how an event can change the presidency, it's as if the presidency is some fixed thing that just responds in some fixed ways to events, as if there's not a great deal of agency as to how the presidency decides to change. And another thing to think about is that ideas about the presidency interact with an event, and those ideas and their interaction with that event give shape to the presidency over time. Just to give an example, there were two presidents facing the crisis of Fort Sumter, and a certain idea of presidential power guided James Buchanan, and a different idea of presidential power guided Lincoln in those early days. And we'll get into that, I think, to some extent through the comments of our panelists. So let me just introduce them very briefly. To my right, by happenstance, is Jack Goldsmith, himself a former head of the Office of Legal Counsel in the Bush administration during a particularly important period in the life of the office and the nation. He's the Henry Shattuck Professor of Law at Harvard Law School, the author of The Terror Presidency, which is a very important inside account of the Office of Legal Counsel during that period, and he has a new and important book coming out on the presidency soon. Next to Jack is Rick Pildes, who's the co-director of the Center on Law and National Security at NYU Law School, and also the Sutter Family Professor of Constitutional Law there. He is an important scholar on these issues, one of the more creative thinkers about the issues that we're facing and talking about. Next to him is Ben Wittes, whom you've met, who is the co-director of the project that brings us here, of this conference, a senior fellow of governance studies at the Brookings Institution, and author of important books on matters we'll be discussing, in particular detention, and a book called Law and the Long War, which organized the debate for the public in many important ways. And then finally, next to him is Deborah Pearlstein, who's an assistant professor of law at Cardozo School of Law, and before that was the founding director from 2003 to 2007 of the Law and Security Program at Human Rights First. So we really have a terrific group of people to help us think it through. What we're going to do is, since the hour is late, though the interest remains high, we've asked them to speak briefer than they ordinarily would, though these are all by nature concise people. Jack is going to start us. I'll ask a couple of follow-up questions, one or not, and then we'll try and have a bit of a free-flowing discussion amongst us. As it happens, many of us have been in conversation with each other offline for many years, so we'll try and bring it online for purposes of today. So Jack, do you want to begin?
Thank you very much, David. Thank you for coming today. So there's no doubt that it's obvious that the presidency today is, by any measure, in many respects, as powerful and more powerful than it's ever been before. It has a set of military authorities that was given to it just after 9/11, and the presidency always swells in authority and power when during wartime. These military powers are likely to remain in force indefinitely. It's hard to conceive the end of these military powers. In addition to these legal authorities and everything that goes with them, the presidency has this gigantic military and intelligence bureaucracy that is bigger than it's ever been, more secretive than, in many respects, it generates more secrets than ever before. It has technological powers that are, again, hard to comprehend. Just think of the government's surveillance powers, think of the authority, the power at the president's behest with unmanned aerial vehicles and all of the intelligence and gathering, sophisticated intelligence gathering that's behind that. So we have this enormously powerful beast. What is remarkable, I think, is that 10 years after 9/11, how much consensus there is in this country about the scope and legitimacy of the president's powers, authorities in exercising these powers. So we've had a lot of fights and debates, and there have been a lot of disagreements in the last couple of days. But really the remarkable thing 10 years later is how settled many of the issues are about the scope of the president's power. So the detention power under the AUMF is basically, I think, a settled issue. It's possible, I suppose, that the Supreme Court could it's settled because we've got lower courts with judges from a variety of perspectives that have agreed that the president has the authority to detain until the end of the conflict, which is basically indefinitely. The folks at Gitmo, we have two presidents that have essentially argued very similarly about what the nature of that authority is, and the courts have agreed with it. Congress is basically on board for at least that much detention authority. There's now a consensus in the country that military commissions are an appropriate option for the president to use to try enemy soldiers of a certain sort, as defined there. There's certainly a consensus that habeas corpus extends to Guantanamo Bay, and at least a consensus at the moment that it doesn't extend beyond that. And to the extent that the Supreme Court might one day take and change that consensus, I think it matters a lot less than one might think, because in fact the detention standards in the shadow of the possibility of habeas corpus, the detention standards in Afghanistan have risen dramatically. So even if the court were to extend habeas corpus, say, to detention in Afghanistan, which I doubt it will, I don't think a whole lot would change on the ground, because people there have been assuming and operating under the assumption that one day they may face habeas corpus. The surveillance authorities of the government are now basically embodied in statute under the supervision of the FISA court. They're extraordinarily broad powers, but they've basically been blessed by three branches of the government. Targeted killing, I could go on and on. Let's say one more. Targeted killing is something that the legal issues have been fully fleshed out and basically made public. Two administrations have used these authorities, and we now have a robust understanding of what the basis for the legal authorities are. We have a good sense, at least from one court, and that this is the question about the legality of these targeting authorities are a political question. So basically, the political branches will work it out themselves, the legal issues. But there's extraordinary vetting of this issue in the public, and there's not a lot of pushback on the president's authority to do that. In many, many other issues, we've reached a remarkable consensus 10 years later about the scope of the president's powers. Now, yes, there are disagreements at the margins, I think. Scope of detention, the kind of disagreement that Charlie Savage was talking about in his story on Friday that John Brennan spoke of. But I think these are really marginal disagreements. There's a somewhat less marginal disagreement about closing Gitmo and the president's power to try members of people in Gitmo in civilian courts. I would still say, you can disagree with me about this, that's a relatively marginal debate. There's no doubt that the president has the authorities. It's a question of how he can exercise them, and there's a disagreement about that between Congress and the president. Anyway, there's this remarkable consensus, I think, and it's remarkable 10 years later that we've reached it. So what explains this consensus and this sort of widespread acceptance of the scope of the president's authorities? One is that the institutions of our government after 9/11 truly engaged with the presidency, especially in the face of a lot of extraordinary assertions of power by the Bush administration. And courts in this country, Congress to a remarkable degree, I've used that word a lot now, to Congress to, in some senses, an unprecedented degree, enacted legislation carefully regulating the president's powers in military commissions and surveillance and detention to some degree. We've had an extraordinary monitoring of the presidency from within inside the presidency with inspectors generals and lawyers. And basically all these institutions, the press and civil society, have been hugely important in generating information and arguments about what the presidency is doing. We've had these giant flurry of fights and pushbacks by all these institutions for the last 10 years. And these resulted in many changes. Resulted in lots of changes on interrogation. By the time at the end of the Bush administration, the CIA's interrogation program was a shadow of what it was at the beginning of the decade, and then it ended when Barack Obama came into power. All of these other issues, we had engagement, pushback, and ultimately acceptance by the other branches of our government. And so one reason why there's this consensus is because all of the institutions of our government have engaged on these issues and basically, and I'm generalizing, reached this consensus. Of course, another reason why there's this consensus is that the Obama administration continued most of these policies. And this is well known. We can argue at the margins about how much they changed things and how much they continued things. There was obviously large changes. There were changes in policy on interrogation and black sites, but on most other issues there was what I would say is continuity with the late Bush administration. But of course, the late Bush administration was very different than the early Bush administration because of all these factors I mentioned. So Glenn Greenwald said in an angry response to the Obama continuation of the Bush policies, he said, "What was once viewed as the signature of Bush-Cheney radicalism is now official bipartisan Washington consensus, the policies equally of both parties and all serious people. Thanks to Barack Obama, this architecture is firmly embedded in place and invulnerable to meaningful political change." I think he's right, but I think he's giving President Obama a little bit too much credit, because Obama came into office and inherited this consensus that had emerged over the previous 8 years. And so it's not just that Barack Obama got into power and changed his mind about a lot of these things. That's an unfair description of what happened. I think that what happened was he got into power and he realized that truly on a lot of these issues he hadn't taken as firm a position on the campaign trail as many people thought he had. But he got into power, and except with interrogation on every other issue, basically after looking at it hard, looking at the threat, looking at the authorities that he had garnered from Congress and the courts, he wasn't going to walk away from those. So it seems to me the remarkable thing about the presidency 10 years later is how much consensus there is about the scope of the president's powers and the constraints on it going forward in this endless war. So let me just close by saying that, so does that mean that the presidency is just right, that we have exactly the right allocation of authorities to the president and constraints on the president? Does that mean that the presidency is not too big or not too small? I think it's very hard to answer those questions in a meaningful way. I think, first of all, we have to not talk about the presidency in very broad terms. We have to talk about particular issues. Does the president have too much detention authority or not enough? A question Mr. Brennan answered yesterday, saying he's got plenty for now. And we can have debates about this at the margins, I think. We can have debates about whether the president has too much or too little power. But in truth, we rely on intuitions that we have in judging whether the president has too much and too little power. Intuitions about the facts, about the nature of the threat. Is the threat really significant? Is it less significant? And intuitions about our moral and legal interpretations about what's appropriate, what type of powers it's appropriate for the presidency to have. I think it's very hard for us to know, in the absence of consensus about these normative issues and a consensus and more knowledge about the threats that the presidency faces, whether the presidency is too big or too small. But I do know that the presidency is an extraordinarily, it is an institution that is watched very carefully by courts, Congress, the press, civil society, lawyers, and inspector general inside the administration. And it is an institution whose powers can change and change fairly quickly when we get new information. So my basic conclusion from the last 10 years is that we're at a place with the presidency that we can be fairly satisfied about. We should never, we can never be too satisfied, but we can be fairly satisfied about where the presidency is now and the powers the presidency has, and also satisfied that in the light of new information that we might get about the nature of the threat or about abuses or problems, that we can change and alter and check the president's powers.
Thank you, Jack. There's two thoughts occur to me. One of which really comes from a concept that you surfaced in your first book, was the idea of enduring legal structures. and I think everybody who's worked in the government in the last several years at least, working on these issues, or at least a large number of them, have in one way or another had some sense that the idea of creating a stable, you might call depoliticized in a way, is an aspiration of many people working in national security policy, whatever that means, fraught with all kinds of objections, but nonetheless as an aspiration. And a question for you is that while it seems right the way you describe the current world, what's hard to know is this an adventitious consensus or is this a stable consensus? And so what might be the factors, this is the first question, that you would see as potentially unsettling it? One could have said prior to Dean Achetson's appearance before the Senate in 1950 that we had reached a consensus about how to face foreign threats, that Roosevelt had walked us through, taken us away from isolationism towards a certain attitude towards Congress. Truman upset that consensus quite significantly. One might have thought we had had a certain consensus throughout the Cold War years from Truman till the time it sort of unraveled. Eisenhower had a different view and so on. So what would be the circumstances that would unsettle the consensus? And then second, is this an indication that maybe this is a direction in which the unsettlement would occur? The occasion for John Brennan's speech was less an analysis of the relative differences between the Obama administration and what preceded it, and rather the differences between the Obama administration policy and the policies of the Republicans in Congress, who have a very different national security vision, at least if one reads the text of the statutes that they've been adopting. And so does that point the way to where the consensus might unravel?
Yeah, on the first question, it seems that the obvious thing that could unsettle the consensus is if the known nature of the threat changes. And Brennan basically said this yesterday. He said we have adequate authorities now, and if we understand the threat will change and that our authorities aren't enough, we'll seek different authorities. And obviously, a large attack could change the nature of the authorities. I think that certainly the consensus now rests on the supposition that the powers the presidency has, and this is basically the thrust of Brennan's speech, the powers that the presidency possesses at the moment are adequate to meet the threat, all things considered, all the trade-offs considered. And if it becomes apparent that that is not the case, then there will be changes. And although I actually don't think that the changes, one can never predict these things, and it depends on the nature of the attack and the scope of the attack, but I actually think that in terms of the sort of the overall allocation of empowering the presidency and watching the presidency at the same time, I don't think that can change. I think the reason we've had the presidents that we've been able to stomach, and that's one way of putting it, or legitimate the growing presidency is because courts, Congress, insiders, civil society are watching the presidency much more closely, and I don't think that will change. But obviously, some apparent change in the nature of the threat could unsettle the consensus. I don't know whether the Republican vision in Congress could unsettle it. I don't know how serious it is. It would be interesting if there is a Republican president whether we will see a large change in policies. I haven't actually studied all the congressional proposals as well as I could have, but in terms of the scope of the war and detention authorities and the like, I mean, if the Congress wants to say that the war is broader than it is, and I think that they are largely motivated, this is not going to be a surprise, by political reasons and not national security reasons, because they didn't have these concerns when President Bush was exercising very similar authorities. It could unsettle the consensus, but I actually think that most of those changes are rather marginal or will have a marginal impact in practice on the president's conduct of national security. So, listen, I acknowledge your point that consensus is only a consensus as long as it's a consensus, but and that the consensus can and that the consensus can change, obviously, with changed circumstances. But we've now had a fairly long period with fairly stable authorities, and again, I'll end it by saying that even if and when there's another attack that requires us to recalibrate the nature of the threat and therefore the nature of the authorities the president needs, I don't see a dramatic change in those authorities, and whatever changes happen to those authorities will, I predict, be accompanied by lots of accountability strings to kind of monitor them.
Thanks, David. And even though the hour is late, I don't want to neglect to thank the organizers, Gabby Bloom and Ben Wittes, and the Hausers, as well as Martha Minow. But in addition, I want to thank the Harvard Law School students, because I've been here for many of these conferences, and there's a level of engagement with these issues here in the student body that's very sustaining, as manifested in the National Security Law Journal, and it's very gratifying to speak about these issues here in particular. Trevor Morrison and Sarah Cleveland began by wanting to make sure that everyone understood they were not speaking on behalf of the administration, and I want to make it clear that I'm not speaking on behalf of myself. My views on these issues constantly evolve, so you're hearing my views as of today on the issues that are in front of the panel. And the questions I want to address may sound a bit surprising. They are, how much does law in fact constrain the exercise of presidential power in both domestic and foreign affairs? And how much should law actually constrain presidential power? And the foil I want to use for discussing these issues is a recent intriguing book on the presidency by Professor Adrian Vermeule here at Harvard and Professor Eric Posner at the Chicago Law School. It's called The Executive Unbound. And I think it provides a provocative framework for thinking about these very significant questions. They say the reality of modern presidential power, not just in the last 10 years, but over the course of the 20th century, is that law does very little to constrain the president. And this is true, they assert, not just in exceptional times, crisis and emergency, but more generally and routinely in the modern state. When Congress does legislate to impose constraints, the laws are typically vague, leaving lots of room for executive discretion. Even these legal constraints, when courts are brought into the picture to enforce them, often lead to very minimal judicial enforcement, either because courts refuse to reach the merits of these issues, or when they do, they're highly deferential on the merits to assertions of executive action and executive interpretation of law. And Vermeule and Posner suggest presidents can act directly in the face of the law and force other institutions, Congress, courts, and others, to try to stop them, and that much of the time these other institutions will be unable, have been unable, or unwilling to do so. So we should abandon as naive and anachronistic the image and rhetoric of a president bound by law. This is something of a legal fairy tale in their view. The imperial presidency is simply a fact, and we need to become mature enough to accept it. And as a portrait of modern presidential power, this view is not idiosyncratic to Posner and Vermeule. Bruce Ackerman, writing from a more liberal perspective, essentially views the modern presidency as effectively unconstrained by law. And he argues we need radical institutional changes to bind the president to law more effectively. Now, Posner and Vermeule think this is actually a development we ought to celebrate or certainly not be anxious about. We ought not to fear the specter of constitutional dictatorship that's conjured up by this image of the unbound executive. First, presidents often can, not necessarily will, but can produce much better outcomes by being unconstrained by rigid adherence to law. After all, laws enacted in a particular context in the past, technology, culture, communications, international dynamics are constantly fluid and shifting, particularly in the modern age. So better off to have presidents make their best judgment, all things considered, about the right action in the immediate circumstances at hand, rather than being bound by laws that weren't written to contemplate the current circumstances as they actually arise. And second, and very central to their analysis, is the view that presidents are constrained very significantly. It's just not law that is the constraint. It's the political judgment of other actors. It's various kinds of politics. And the reason for this is that the president's power is effectively deeply rooted in his credibility or her credibility, and it's limited by the president's ability to maintain that credibility. Presidents are permitted, in effect, to exercise more or less discretion, including discretion to ignore or bend the law, depending on the conclusions others reach about how well motivated they are, how good their judgments are, what the consequences of their actions might be. And presidents seeking to enhance and maintain their credibility are then going to have to do a lot of things along the lines of what Trevor Morrison suggested this morning. They're going to have to adopt various self-binding mechanisms that signal that they respect various limits on their discretion, like transparency so that others can monitor what they're doing. Now, here's a concrete example of what this view means in practice. Posner and Vermeule argued during the debt ceiling crisis that President Obama should simply have asserted a unilateral power to honor and fund the United States debt, regardless of whether the constitutional or other legal authorities gave him the power to do this or put this power in the hands of Congress alone. Given the potential crisis to the U.S. economy, the world economy of a default, he should simply have acted and asserted the power to act and let other actors sort out the consequences from that decision. And this view goes back to the early part of the 20th century. It's been articulated by modern architects of the very powerful presidency, like Woodrow Wilson, who said the office allows the president to be as big a man as he can be. And he said that with reference to purported constitutional constraints. So if President Obama refused to, or if he followed this course, it would not be, or his failure to follow this course, I should say, reflects a lack of nerve or a lack of understanding of actually how much power he effectively has. Now, this approach that Posner and Vermeule take is, I think, actually characteristic of a variety of ways of thinking about the behavior of public officials these days. It's a view that public officials are not bound to the law out of some sense of moral obligation or some sense of official duty. It's a kind of hard-headed realism in which all that matters is what the consequences are that might be from following or failing to follow the law. If other actors, including political actors, will accept the action, then the president will be able to take this measure. And if not, his credibility and his power will be undermined. So it's kind of a cost-benefit calculation, not some sort of obligation to obey the law that determines how presidents act in fact. Now, we could respond to this view by offering up various case studies in which presidents appear to be constrained by law, and then we'll get in an endless debate of competing stories, or we could look to the testimony of people who have served in government who will explain that they gave legal advice to the president and he followed it. But we might need to worry about how self-deluded or self-serving those views might be. So I wanted to actually raise what I think is a deeper problem about this whole way of thinking about presidential power and its relationship to law. I think even as a matter of hard-headed, pragmatic realism, the problem in this view is that we cannot separate law, which is supposed to be kind of irrelevant and no constraint, from the so-called real constraints of politics or public and political responses to assertions of presidential authority. And if presidents have to signal their credibility by binding themselves in advance in various ways, as Posner and Vermeule insist they must, the single most powerful signal of that willingness, particularly in American political culture, is the president's willingness to comply with law. So if we suppose that Congress had refused to increase the debt ceiling and President Obama went ahead and did this on his own, what do we imagine would actually happen? The goal of avoiding default is a goal that would be widely shared and would have been seen as desirable. And despite this, it's my firm belief that the turmoil to the U.S. markets and the world economy would not have been much different than had the United States actually defaulted. The country would have been tied in knots for a year or more about whether the president had acted lawfully in doing this. Impeachment surely would have loomed as a possibility. And why would all this instability result? Not because of the substance of the action, honoring the debt, but because of perceptions that the president was, in a sense, throwing the whole constitutional order up for grabs, that no one could be certain whether any bonds issued to pay off the debt were legally valid, that the U.S. was turning into a kind of banana republic in which presidents were free to do whatever they thought expedient at any particular moment. And I think the key point here is that the world of public and political responses to presidential action is, particularly in the United States, filtered inevitably through law and perceptions of law. There just is no separation between law and public or political judgments about presidential action. Public judgment is always refracted through judgments about whether various actors, including the president, are acting lawfully. And I think that point is demonstrated by the piece that Jack just published in the New York Times in which he quotes both President Bush, George W. Bush, and Donald Rumsfeld, acknowledging that assertions of unilateral presidential authority for some of the measures taken in the early days after the war on terror began were actually self-undermining to the presidency and the capacity of the presidency to generate support and credibility for the actual substantive choices that were being made. But I want to end on a little bit of a challenging note here. Lawyers and legal academics, in particular, I think, tend to believe that compliance with law is not just an important value, but the highest value, that law does and should trump all other considerations. And that's why people like Bruce Ackerman want to create a new court that will force the president to comply with law in every context. But if the right way to understand presidential stances towards law, both descriptively and maybe normatively, is a kind of cost-benefit calculation in which compliance with law is and should be treated as a very powerful, maybe uniquely important factor in pragmatic judgments of what to do, then perhaps it might be true, as a descriptive matter, that presidents do sometimes decide that other considerations weigh more heavily than legal compliance. Numerous State Department legal advisors have said in print that when it comes to use of force issues, national security and national interest considerations overwhelm legal considerations. And so it may be that for both moral and pragmatic reasons, compliance with law is an exceptionally important value. The question is whether it should be the only value or the highest value that trumps all others in every context. Thanks.
Thanks, Rick. I think the debt example is very helpful. I often wondered in that debate who exactly was expected to buy the bond that came with an asterisk saying this was a bond issued in violation of the laws of the United States of America. But I think the deeper point you raise is a very important one, and I want to put it together with Jack's point and get a sense of what it suggests the public should do with these 2 points together. So Jack's point is that the accountability mechanisms, the surveillance of the president, is a very important mechanism for ensuring that we have a presidency who is not an unbound executive. Your point is that we need to have a very mature and sophisticated understanding of the degree to which the president is always both bound and unbound. And if one adopted your view, what would happen to the instinct to surveil the president? So would the public consciousness that's generated by the external view you have, an assessment of the difficult trade-offs that a wise president makes, would it undermine the energy and instinct that galvanizes a lot of the surveillance that Jack's account depends upon? Would it delegitimate it if we adopted your stance? And if so, then there's a complicated relationship between these 2 points in which we sort of need a public which subscribes to a less sophisticated and mature assessment of the presidency's place in our culture than you describe in order to ensure that it remains the kind of bound presidency that you both think is optimal.
Well, let me start off by saying that I'm trying to enter into the kind of pragmatic, cost-benefit, realistic view on presidential power and law of people like Posner and Vermeule without, myself necessarily endorsing that. So, especially since this is being recorded, I thought I should make sure to say that. But I don't know if it would, in fact, change very much. I mean, the perception of the importance of presidential credibility and integrity, the perception of the importance of law and of legal compliance, I say particularly in American culture, because I don't know if people realize how profoundly that characterizes American culture in a way that is not true in every democracy in the world. There are countries that have much more instrumentalized views towards law than the United States does. But when you think about how much of our post-9/11 debates were debates not about the substance of policy, but about lawful process and authority. Can the president do this on his own? Must Congress endorse the president's action? Must Congress permit the president to act? I'm not sure that I see why all of the intensity and concern about that that's currently present in the United States would diminish if there were some broader recognition of this more cost-benefit stance towards law. In fact, I think Posner and Vermeule's book is very interesting in part because it captures a kind of cynicism about presidential compliance with law that I think is actually, probably fairly widespread. I think it may be already that there is a view out there that's not an idiosyncratic view, that presidents act in the ways they think make the most sense and are politically expedient, and lawyers are brought in to justify this after the fact. And of course, some people have already referenced the Libya issue in some of the earlier discussions, and people will have different views about how to understand the legal arguments about the authorization for force in Libya. So.
Great. Ben.
So there's always a risk when Jack and I are on a panel together that whoever goes second has nothing to say because the other sort of says everything that the first was going to say. And I'm happy to say that's not actually true this time because I actually disagree with something pretty substantial that Jack said, which is not the fact of the consensus that he describes, but his perception of the durability of the consensus. And I want to start by telling about a conversation that David and Deborah and I had last night over dinner, in which, invariably when we all get together, there's some discussion about the question of continuity and change between the Obama administration or the Bush administration and the Obama administration. And this question developed, and there's, all the usual themes get trotted out. And Dave finally said, actually the real issue is not continuity and change between the last administration and this one. The real issue is the question of whether the degree of consensus that's developed is about to be radically upset by what's being proposed in Congress by the president's political opponents. And I think that point is actually exactly correct. And in fact, it's so correct that my response to it was to look to my left. She's now sitting to my right, but ironically enough. And I said, that point is so correct that Deborah and I, who have been arguing with each other for 7 years about the legitimacy of some of these presidential powers, are now ironically on the same side of the debate, which is against, irrespective of our disagreements about what powers the president should have with respect to detention and some other areas, the very strong sense that the use of those powers should not be mandatory. And so Jack actually described the consensus in some detail, and I'm not going to rehash what he said. I do think there are a few salient features of the consensus that are worth, I guess, points that I would make about it that he didn't make, which I will go over. Whether you think of this consensus as a feature, largely a creature of the mellowing of the Bush administration in the later years, I think it certainly has, that's a very strong part of the theme of the development. There's also a part of the development which, people earlier in the day have talked about, which is that, the Obama administration got into office, as Jack describes, and Ben Wisner did not get what he wanted, and the left lost a lot when the Obama administration got into office and decided which part of what the last administration claimed the authority to do they were going to continue. And so that combination of the mellowing of the Bush administration over time and the, whatever you want to call it, you can call it a betrayal, as Glenn Greenwald would. You can call it a growing into the role that you've found, as somebody might, you can call it a come to Jesus moment. You can call it whatever. But there was some point at which the Obama administration really had to figure out what it was and wasn't going to give up, and it gave up a lot less than a lot of people expected to. And the result was a sort of emergent common ground, and I think the common ground is characterized in all the ways that Jack described. You can break it down by very specific subject matter, but I think it has three basic big themes. And the first is, one, that this is a presidency of enormous power, that the substantive powers of the presidency did not change a great deal between the Bush administration and the Obama administration. And that this is discretionary power. As Trevor was pointing out before, and as John Brennan said last night, confronted by a given detainee or target or potential defendant, all the options are on the table, and that's an enormous power. So that's theme number one. Theme number two is that these are powers that are justified relatively modestly, certainly compared to the early Bush administration. Even by the late Bush administration, there was a much greater, thanks in large part to Jack, I think, there was a great tendency to rely on statutory law rather than assertions of Article II inherent authority. That trend has certainly continued, accelerated even. And so you have this combination of a presidency of enormous powers justified modestly. And then number three, and this point doesn't get talked about, I think, as much as it should, which is, we always have the question in the war on terror, is it law enforcement or is it war? And there isn't an emergent sort of answer to this question. It's not, it's a crude cut, and you can find exceptions to it. But early in the Bush administration, there was a real question: was it war all over, including domestically? And there were people who were arguing, no, it should be law enforcement, including everywhere abroad. And the broad emergent answer thematically, in my opinion, has been domestically, the war on terrorism looks a whole lot like law enforcement, and overseas it looks a whole lot like war. Now, there are exceptions to that, but it's a pretty good rough cut. And I think it describes the mood of the late Bush administration. It describes the mood of the Obama administration. And I will go out on a limb and say in a Perry or Romney administration, the broad contours of that consensus will not be profoundly disrupted, which is to say, I'm sure just as Obama promised to close Guantanamo on day one, Perry or Romney would promise not to close Guantanamo on day one. So there would certainly be some optical changes and some non-optical changes. I think an OLC run by David Barron is a different place in terms of presidential power than it would be among some of the people you could imagine holding that office in the next administration. So I don't want to overstate the point. It's not that there would be no change, but the broad parameters of this consensus that Jack describes and those three themes that I just described, I think among have become something of a matter of consensus across parties, among people likely to occupy significant decision-making executive branch positions. So that's the sense in which I agree with Jack. Now here's the sense in which I don't. The proposals that are now being considered in Congress are a dramatic rebuke to that consensus. So they reject the idea that all the options should be on the table. In fact, and this is why I find myself I think, to both of our somewhat discomfort, I'm feeling very, in touch with my inner Deborah Pearlstein. I have argued for 7 years that these tactics are legitimate. It never crossed my mind that their use was mandatory. And I would never have, in my most, I would never have argued that it should be unlawful when you capture somebody to subject him to an Article III trial, that you have to hold somebody in military detention, even somebody you caught domestically. So this is a great upset, I think. It's quite notional at this stage, of course, but it's a great upset to all three of the big themes of the consensus, right? So, theme number one, while it's not a presidency of great power anymore, right? It's a presidency that is very narrowly directed by Congress to do the most controversial thing. It's not a presidency whose powers are just, I mean, I guess its powers are still directed by Congress, so it doesn't go to the justification. But it is also very disruptive of the idea that that the borders of the United States mean something in terms of the concept of what the paradigm is. Now, I'm going to stop momentarily, but I want to talk very briefly about why this has developed. I can think of only two explanations for it. I honestly don't know. I think the answer is a combination of the two. But one of them is the one that Ben Wisner raised earlier, which is simple partisanship, right? And some of the quotations that he cited, that it is a little bit hard to take seriously someone who would say those things. And one has to ask the question, why are a certain set of ideas on the table now that were never on the table before? I don't like to attribute ill motives to people, and I'm not going to do it here. It does raise the question of partisanship in the national security arena, where frankly it's least attractive. The second one, which I'm sure also plays a very substantial and I think under-discussed role, and I think a very important role that we need to confront, is symbolic politics. When Bush was in office, nobody, even those who hated him most, doubted his commitment to fighting the enemy. And so when Bush would decide in a given case that you wanted to bring somebody to New York and try him in New York, or Richard Reed and try him here, that didn't symbolically say anything to anybody. It didn't say we're returning to a law enforcement paradigm. It didn't constitute a rejection of the war metaphor or paradigm or reality, because nobody doubted Bush's commitment to it. But when Obama does the same things, it does raise those doubts in people's minds, in part because he actually is uncomfortable with aspects of the war, the war concept, and states a preference, including Brennan's speech yesterday very clearly states a preference for dealing with things in a law enforcement context when possible. And it turns out, and I think some of us really underestimated this, to be honest. It turns out that there is a very large constituency, and I don't think this is simply a partisan issue. I think it's a spiritual issue for a lot of Americans, who are committed to the idea of a war paradigm, and that is actually a meaningful thing to them. And that when you say that we're going to bring KSM to New York, part of what they hear is, I don't believe we're really at war. Now, that is exacerbated, to be sure, by the partisan dimension of it, and it's further exacerbated by a sense that there is a group of people who do doubt Obama's commitment, though I can't, given his track record, I can't imagine why. But I do think that that symbolic component of it, and that we have to figure out a way to talk about these things such that talking in the language of using all the available tools is not seen as a rejection of somebody's core symbolic commitment to the conflict, is going to be a real challenge, certainly for this president, but I think for any president over time who wants to not be, a chest-thumping war paradigm kind of guy. So I'm going to stop there.
Thanks very much, Ben. There's a not surprising quality of consensus among the panel, given that each of them then tells you how important consensus is to be adopted. But I agree with much of what you're saying, and just to amplify it and maybe your reaction to it, you identify the domestic law at home and the war abroad, and I think Brennan's comments were focused very much on the domestic Article III tribunals being used for domestic captures, not a preference for law enforcement generally. But One interesting phenomenon of this is that the war law enforcement paradigm was one cut of the debate, but a separate cut of the debate was what is war? And that's a separate thing. What are the features of legitimate war? But I think it's very much the case, and I'd be curious your reaction to it, that even that debate then got allocated to one side of the law enforcement war paradigm. So just to give an example, the executive order interrogation, the move was to apply the Army Field Manual, which I think may have been experienced by many people as a walking away from the war, which in some ways is an ironic conclusion to reach, right? The president, as a senator, had voted for the Military Commissions Act, a different version than the one that passed in 2006. Not an indication that he was walking away from war. He was endorsing tribunals that are only permissible under the law of war. And the debate was, what is the content of the law of war? To me, one of the important developments of consensus over time has been a much more focused understanding of what war is, that it is a legal concept with rules and aspects to it that constrain, confine, and empower. But I think, unfortunately, that has been symbolized in a way in which it's not the real war in some way, and so that even embracing the war paradigm in some way falls right back into the very set of ideological debates that you're describing. It's really more of a comment than a question, but what do you think?
No, I think it's absolutely right. I mean, look, there's a sense in which when you're talking about, the damage that American counterterrorism efforts may do to relations abroad, a conservative president can't win, right? Because if they, and when you're talking about the things that you refrain from doing out of sensibilities for the damage you might do, a Democratic president can't win. And but I think the symbolic dimensions, and Obama definitely falls into that. He will get criticized as, if he ramps up, the drone program by 2 decimal or 3 decimal points rather, which I think he's already done it by 2, and kills Osama bin Laden, he'll be considered weak. So I do think there's an element of it that's simply the perception, both a self-perception and a perception of their political opponents on the part of liberals that security is the other guy's domain, and so there's a tentativeness in the way one talks about it, and there's a tentativeness about what people expect on it. But I do think the symbolic issue is deeper than that, and I think when Obama announced the interrogation executive order, to use your example, he talked about much more about what he was rejecting than about and about the things that he wasn't going to let happen anymore. Then he talked about, what the Army Field Manual really is. And he certainly didn't talk about, the tough things that Appendix M in the Field Manual actually permit, right? And he didn't talk about, what the things that the Field Manual lets you do that make it a functional document from the point of view of actually conducting, wartime interrogations. And similarly, the administration talked about the Military Commissions Act in 2009 very little, actually. It proceeded to get it very quietly, and then having gotten it, it spent a very long time talking about all the cases it wasn't going to bring in it, rather than the cases that it was going to bring in it. Now, there are good reasons for that, but the result was not that it conveyed, we're at war and here are all the war authorities we're using. And I think, I think the atmospherics of it, partly for reasons of its own discomfort with talking about them in that language was difficult. I also think that, and there are exceptions to that. When David Criss came and gave a speech at Brookings, he talked, he said a lot of things that were all of them consistent with administration policy, and it sounded very different from the way the administration often talked about those things. And so I I think there is your point is very well taken, and I'm sure some of the situation would have developed in any case. But I do think there is a sensitivity to the fact that there's a sensitivity that was lacking, and was certainly not lacking last night when Brennan talked, but for a long time was really lacking, that there is a symbolic sense in which the American people is discomforted by the idea that the rhetoric and way of and style of talking about the presidency in this should be more rather than less divorced from warfare.
Deborah.
Well, thank you. I am so grateful that you are all still here for the last panelist on the last panel of what is, from my point of view, been truly a wonderful conference. So I want to join everybody in thanking Gabby and Ben for putting this together and for including me. And I must thank the incomparable Martha Minow as well, who I should point out, in addition to being the dean of the Harvard Law School, was the professor that I had in my very first class on my very first day at the Harvard Law School for civil procedure, at which time I was still equivocating on my conviction that this was the right course in life to take, and came out of that class quite strengthened and indeed solidified in the conviction that I had quite made the right decision, a conviction that has not wavered since, so thanks. In any case, what do I want to say? Well, with resisting the temptation to sort of respond to everything that's already been said directly, I want to try to at least spin out a slightly more positive story. And this is not just because I'm the last speaker, but I recently wrote an article, or at least an essay, trying to understand what the last 10 years has taught us about the thesis of the imperial presidency, and in particular, the one-way ratchet theory, which I'll define in a minute. So I want to try to ask and give a tentative answer to that question, which I admit requires a certain amount of looking back, and then maybe make a last 3 minutes worth of remarks that try to look forward. So the thesis that was very much the one I grew up with in my law school education, if not before, comes from the great works of Schlesinger's Imperial Presidency, and in an earlier era, Harold Koh's National Security Constitution, and many others. And the thesis is, and I think we've heard it in various forms restated here, that executive power not only expands during wartime, it expands historically and it doesn't contract. In essence, there's this one-way ratchet that is in effect. And the mechanism that drives the one-way ratchet in favor of the expansion of presidential or executive power is the result of two particular phenomena. One is a political effect, that political incentives only and always drive presidents to want to accrue greater power, particularly in times of crisis, to be seen, to respond, and to be seen as responding. And the second aspect of the mechanism that Koh and Schlesinger and many others have described is that the president not only has great incentives to seize power in this way, but the other branches have every incentive to let him have it. And in this way, the other branches essentially submit to the expansion of the imperial presidency, and 225 years later, here we are. So is this the story of the last 10 years? And in this question, and this requires me to look at both Bush and Obama administrations, I want to be clear, I'm not talking about the continuity or not of particular policies. So what should our detention policy be? What should our interrogation policy be? And I'll use some examples from that context, and I'm delighted to talk about that further at length. But I'm asking it from a separation of powers perspective, right? Who's exercising the power, which branch, and why in testing this thesis? Okay, so let me put forward two examples from the last 10 years, and they're chosen, and I can put forward others, but they're chosen to be, contrary to some extent, or at least to tell a more complicated story than the story I think told by the one-way ratchet as a general matter. Okay, so example one, torture. For many people, I think probably the most extraordinary claim of presidential power by the first Bush administration was the usually attributed to John Yoo memo that claimed, among other things, that it would be unconstitutional for Congress to impose constraints on the executive's power, president's power as commander-in-chief to order his agents to conduct I'll, in a very controversial way, use the word torture purely in the interest of time, and we can fight about that too in a minute, to use extraordinary interrogation techniques in order to obtain information that would help keep Americans safe. So this was an extraordinary claim of presidential authority in a lengthy legal opinion that didn't cite the Steele seizure cases, among other things, which, if you were my law student, would not serve you well on an exam. In any event, so doesn't this example alone tend to support the one-way ratchet theory sort of extraordinarily, right? Political incentives of the time were driving the president and his agents to claim broader and broader power. There was great sort of cultural support in the form of TV shows like 24 and others that this was the kind of thing that worked and that daring Americans would do. And that indeed, since then, the courts have rejected the vast majority of efforts to obtain civil forms of recompense for victims of torture that were alleged to be carried out at the hands of the United States. So isn't this sort of the perfect example of the one-way ratchet at work? And I want to say two things here. One, no, because of the following examples of counter efforts that I'm going to give. And the second is to say, just from a historical perspective, because this was one of the issues I worked at very much at the time when I was still in practice, the notion that this issue was somehow easy, or that the resolution of this issue was somehow predetermined. Obviously, we were going to realize that John Yoo was out of his mind and that torture was a terrible thing, and we would figure it out and reset the clock, was so far from the, seemed so far, at least from, say, 2002 to 2005, the obvious or in any way predetermined outcome for a variety of reasons. So, for example, you have, without the change of presidential administration, Congress in 2005 passing the Detainee Treatment Act that did a lot of things, but among other things included the so-called McCain Amendment that tried to make clear, no matter who you are, Army, CIA in particular, when you are acting under the authority of the United States, you are not to engage in either torture or cruel and human and degrading treatment and follow the Army Field Manual and so forth. My favorite story from lobbying efforts of this era was when Vice President Cheney went to the Hill to try to talk Senator McCain, then Vice President Cheney, went to try to talk Senator McCain out of continuing his support for this amendment, and Senator McCain pulled out of his pocket, and I always imagine this, and I'm sorry because it reveals my prejudices, this sort of vampiric airing of the cross. I mean, he pulled out of his pocket a letter of that had been signed by, by then I think 40 or 50 retired admirals and generals of the U.S. military, saying we thought that the McCain Amendment was a good idea, and sort of waved it in front of Dick Cheney's face and said, this is the constituency to which I'm responding. And in that respect, right, despite vigorous and ongoing until the very final hour efforts by the president and his administration to resist that sort of mild piece of legislation, the bill was passed. The following year, the Supreme Court decides Hamdan, a decision that for most of its litigation history, most said was a non-starter of a case and indeed tilting at windmills, in which, though ultimately the Supreme Court ultimately holds that Common Article 3 of the Geneva Conventions, which with its protections against cruel treatment applies to the war on terror, for lack of a better term. And then with Obama's election in his first sort of day or second day in office, issues these executive orders that essentially reinforce and to some extent strengthen the anti-torture regime that was already in place. Now, this is 2002 to 2009, right? This is not a fast-moving ratchet in the other direction. It was 2002 that the first reports came out, and I think it was Dana Priest's article, probably in the Washington Post, about deaths in custody of Afghan detainees in U.S. custody who died as a result of blunt force trauma, according to the Army pathology reports. This was a long time coming, but it, I think, can't be described as anything but the ratchet turning in another direction. So from a separation of powers point of view, at least in that limited sense, how do you explain this? How do you explain why Congress and the courts acted to step in at all, right? Especially before there was a presidential election. what political incentives could explain the choice of President Obama to, it appeared, ratchet back the insistence that presidents had the power to use this authority? And I think those are important questions. I'll propose some answers in just a minute, but first I want to get one other example on the table, and that is from the detention context, which we've been talking about all weekend. And here, as other speakers have mentioned, right, we had claim in the early Bush administration that all the president needed was his Article II authority under the Constitution, and that gave him the power to detain and detain with indeed little or no process Jose Padilla, Yasser Hamdi, and then the detainees at Guantanamo Bay, and indeed quite firmly without the independent judicial review of the Article III courts. And you might say, from a one-way ratchet point of view, well, I'm going to be close. Guantanamo remains open, Afghanistan detention continues, this is what it is. But it's very difficult to say that either Congress or the courts ratified in any way that initial Bush administration choice, right? There's been, over years, this incredibly iterative process among the branches that I think the other speakers have referred to as well. Most recently, extraordinary efforts by Congress to restrict the powers of the executive to transfer detainees from Guantanamo Bay. You can use the debt example if you want to go outside the terrorism context. Efforts to restrict presidential power to which the president has largely capitulated. And indeed, I would say it's essentially entirely capitulated. So how do you describe this? How do you account for the fact that it is now Congress and not the president that is seeking arguably greater detention authority, a sort of renewed and expanded sense of the armed conflict we're now in? Why don't political incentives lead Obama to seek renewal on his own of the authorization of the use of military force? And I think the answers, and this goes to my forward-looking account, are the following. And you can tell me, guys, why I'm wrong. Number one, the realization that it's possible for the mechanism, the political incentive mechanism that drives the one-way ratchet, to push it in either direction. Namely here, and we can debate about whether you call this law or not, there were political incentives in the form of, among other things, our international allies, in the form of an increasingly powerful domestic uniformed military constituency, which is another topic, that can push executive power in the other direction. And I think that's a sort of remarkable phenomenon that needs to be attended to and understood to some extent better. The second, and these are my final sort of prescriptive points going forward, I think one of the conclusions I want to draw from this is that the descriptive claim that executive power invariably expands in wartime and it is sustained in its expansion and so forth was a claim that I remember hearing circa September 12th, 2001 by Michael Ignatieff and all kinds of people, right, left, center. And I found it so troubling, in part because this was September 12th. We scarcely knew who attacked why, what happened, what the holes were, and so forth. And we were already in a sort of descriptive, self-fulfilling prophecy explaining why we knew exactly what was now going to happen. That is, the president would now seek greater power, and we would all sit back and watch it happen, at least for a period of years. I would like us, in the event of the next attack, when the next attack comes, not to be so easy to embrace that descriptive certainty that becomes, in my view, a sort of descriptive license for whatever happens next. And finally, apropos of what some of the other panels have highlighted, yes, this is finally, 30 seconds I can do. I think we need to move past the idea that this has been an exceptional issue, that terrorism is an exceptional problem, an emergency kind of problem, a problem that is centrally dealt with by executive power, to the idea that what we're dealing with is chronic threat management. And how do you engage in that? And the organizational ways in which one might engage are complex and lengthy, but at a minimum, it moves us past this idea that the institutional competencies we especially associate with the executive, right? Unicy, secrecy, dispatch, the Alexander Hamilton notion of good security government is not all we're talking about anymore. It's hardly sufficient to explain what we want to be doing as we fight chronically terrorism going forward. It asks not when is this ever going to end, but recognizes this is the world in which we now live. What do we want it to look like as a matter of law and as a matter of separated powers? And that's the question I hope we can talk about going forward.
I think unfortunately we're going to have to stop because we want to hear from Charlie Savage in about 20 minutes. So I want to thank all the panelists for your remarks.